All right, so it looks like we're live. Ashley's going to send me the presentation now. I'm sorry, we're not able to locate it, but I want to welcome all those board members that are here today. Appreciate you taking the time out of your day to be here with Robert from Siegfried, as well as myself. So while Ashley sends me the presentation, Robbie, why don't you tell the guest a little bit about yourself and the firm?
Absolutely. Thank you very much, Rafael and Affinity, for inviting us to partake in this webinar to present for all of those attendees some of the general points related to annual meetings and elections, as well as some of the more current issues that we are encountering. As indicated, my name is Roberto Blanche. I am one of the shareholders at the law firm of Siegfried Rivera. And for those not familiar with our firm, we have been practicing for over 40 years in the South Florida market. I have been with the firm for about 20 years now, and my practice is dedicated exclusively to the representation of community associations such as cooperatives, condominium, and homeowner associations. So we look forward to providing some insightful commentary today and some basic points as well with regard to the subject matter of this presentation. I don't know how we are going to be set up with regard to the taking of questions. I noticed that there is a Q&A feature on the webinar. And so perhaps at the conclusion of the presentation or my presentation, we can take some questions. And I am certain, having had experience with Rafael presenting previously on other subject matter with regard to community associations, I would expect that he's also going to keep it lively with some of his commentary and questions as well. So I invite that and look forward once again to a good presentation.
Sure. Thank you, Robert. So yeah, my name is Rafael Aquino. I'm one of the co-founders and CEO of Affinity Management Services. We are an association management company. Over the past few years, and more so, I would say the past year, and so our focus has really been in growing on the on-site sector, those associations that have on-site managers that need management services. What separates us is what our specialty is really those associations that are looking for a bit of a more high touch. We provide you, the services that the larger player have, but more, where you can have direct contact with the owners, and we have all the resources that the larger organizations are going to have. With regards to today's presentation, I'm looking forward to all the information Robbie is going to provide us today. We'll go ahead and manage the Q&A. So if you have any questions or anything that you want to point out with regards to the slide that you need a little bit more detail, feel free to chime in. Based on my experience over the past year doing these webinars, we have realized that sometimes we can't get to all the questions. So if we're not able to do so, feel free to reach out to Stephanie, myself, Robbie, or Ashley, and I'm sure we'll get back to you with whatever questions you may have. So enough about us. I think we're all here to learn a little bit more about annual meetings and elections. So Robbie, you want to go ahead and take it from here?
Sure, absolutely. So what we'll do is we'll give a pretty basic, like a 101 overview as to the two main community associations with which we are confronted on the day-to-day of our practice, and that is, of course, condominiums and homeowner associations. As the attendees may or may not know, condominiums are created by statute, and the applicable chapter is Chapter 718 Florida statutes. It's not to say necessarily that they're created by the statute, but they get their authority, or an individual or a developer desiring to establish and create a condominium association must do so pursuant to the terms of Chapter 718 Florida statutes. We noticed that the sections of Chapter 718 that establish condominiums and how they are to be governed indicate that they are to be governed by a corporation, not for profit. And so what we do is we also, as practitioners, whether it's as attorneys or property managers, and also to a great extent board members, we also need to be mindful of the laws that govern corporations and corporations not for profit in particular. And so we need to focus on Chapter 617 as well as Chapter 607 of the Florida statutes. There is also a series of what we call division rules, which is a more informal term to make reference to sections of the Florida Administrative Code, wherein administratively entities such as the Department of Business and Professional Regulations in this particular case may have promulgated additional rules that elaborate further upon the statutes governing or pertaining to these community associations. And so we also pay attention to those sections of the Florida Administrative Code. For example, when we are presented with an issue of a runoff election, right? If we ever have an election of a condominium board and there is a tie, that prevents us from having elected the full board. Let's say, for instance, that we've got a 3-person board and we have a tie on the votes received by candidates 3 and 4. Then, third and fourth place. Then what we do is we need to have a runoff election. Well, when you look at Chapter 718 Florida statutes, and usually your own condominium association documents, they're silent with regard to how to run and administer a runoff election. And therefore, had it not been for the provisions of the Florida Administrative Code that govern that, we would have no idea what to do. And so as a result, it's a good illustration for the instances in which we need to be mindful of yet another layer of regulation or rules or procedures that govern our associations, and in particular with regard to the subject matter of elections and annual meetings. And of course, you've heard me mention it before, we've got the governing documents in condominium associations. It's the Declaration of Condominium, the articles, the bylaws. We also like to throw in there the rules and regulations as well. So we talk about governing documents, we need to pay attention to those as well, because they usually have provisions governing the annual meetings and elections. And there are some sections of the statutes that defer to the authority provided in the governing documents. For instance, if your governing documents specify what the quorum is for members' meetings or annual meetings, or other particular issues with regard to elections, we want to be mindful of those sections because they will preempt, in most, if not all instances, what is included in the statutes. So we need to, and I want to mention that also with a little caveat. For instance, the statutes provide for certain minimum thresholds as to what is required for quorum. Similarly, what is required for an election. If your governing documents provide, for instance, that in order to have an election, you need to have 50% of the owners casting ballots, but your statutes provide that you need to have a minimum of 20% of the eligible voters submitting ballots, then we defer to what the statutes provide because they are the least or the lesser of the restrictions, because the objective is to allow the constituents to have an election. And so if we were going to govern in that case and apply the standard imposed by the declaration or the bylaws of that particular hypothetical condo, then it would be more difficult to achieve an election. And so what the legislators had as an underlying desire, I guess, or intention is to allow for greater participation of the constituents of the voting interest in a condominium. And so that's why the threshold for elections in condos is set at such a low number, which is 20% of the eligible voters. And yet, with that said, we do know that it's been difficult to have that 20% nonetheless in many condominium associations. So, that gives you in a nutshell what the condominium documents or paradigm of regulation is. As it relates to homeowner associations, we reference Chapter 720 Florida statutes, which historically has been more flexible and less restrictive than what Chapter 718 typically provides. However, there has been a trend, I would say, in the past decade or so to increase the regulation of HOAs. And so with every given legislative session, it seems more and more that there is a current or an undercurrent of legislation that is aiming to impose more restrictions or protections, I guess, upon homeowner associations. And so while it is not there now, it isn't, I would say it is foreseeable that potentially at some point in the future, maybe the distant future or not so distant future, if these trends continue, you may find that Chapter 718 and 720 look more and more alike than they do right now. Homeowner associations as well are not-for-profit, generally speaking, and so you are again mindful of Chapter 617 and 607, and you also want to be mindful of the governing documents and what they provide in an HOA with regard to annual meetings and elections. And lastly, while the administrative code does not govern too broadly the homeowner associations and the elections in homeowner associations, we also do pay some attention to what is provided in there, because, for instance, there is a provision in there where the DBPR or the division of condominium and mobile homes, et cetera, which is a section of the DBPR, has jurisdiction over election disputes of homeowner associations. And so this is an example that even though the division of condominium doesn't typically have jurisdiction over disputes, et cetera, of HOAs, there has been some extension of their jurisdiction or their authority to at least preside over disputes relating to elections of HOAs. So that's a good foundation of the laws and procedures that govern condos and homeowner associations. Now, as we move on to the next slide, we get into the discussion of condominium board meetings. And there are going to be some similarities between how the board meetings for condos are conducted and addressed, as well as how the board meetings in an HOA setting are to be conducted and governed. But we will bifurcate the discussion and address on this slide condos and condo board meetings. Now, the annual meeting, generally speaking, is not a meeting of the board, and the election is not a meeting of the board when you're looking at this from the perspective of condominium associations. And it's interesting to make note of that, because when you're talking about a condominium association annual meeting and election, you're really talking about two processes that are, on the one hand, independent of each other, but also depend upon each other to some extent. And what I mean by that is, it is entirely possible to have an annual meeting, because it's a meeting of the members and it necessitates a quorum of membership or of the association members to be present in order for the annual meeting to take place. And so by statute, the default quorum is a majority of, well, we're talking about the board, but as it relates to the annual meeting, you've got a threshold of what is required in order to have an annual meeting of the members. And then what you need to have a election is a different threshold. In order to have an election, you need to have a minimum number of ballots cast. And so it's possible, for instance, and it's happened numerous times, where you have an election but no annual meeting, or you may have an annual meeting and no election. You may have neither, or you can have both. So This all really depends, because you got to look at it from both points of view. Have you achieved enough participation by the members, whether in person and by proxy, to have a quorum for the annual meeting to take place? And then again, you need to ask yourself whether or not you've received enough votes, enough validly cast ballots of the unit owners in that election in order to have an election. Now, what we then realize is that board meetings and the annual meeting and the election, while they are different processes, have nothing to do with a board meeting. They are not board meetings. Nonetheless, we want to understand the way they work, and so with regard to condo board meetings, we discussed that they're open to all of the membership of the association. They can only be closed meetings for two situations in condos, and that is a meeting of the board to discuss personnel matters, as well as a meeting of the board with the attorney present to discuss proposed or imminent litigation for the purpose of the attorney rendering legal advice. Those are the only two reasons why a board can have a closed meeting in a condominium association. For all other discussion, it must be open to the members, because once again, as we indicated earlier, the legislature wants to have open discussion, wants to have transparency, and wants to have the membership provided with an opportunity to know what's going on with regard to the governance of their condominium association. All board meetings need to be noticed at a minimum 48 hours notice with an agenda. The agenda has to include all of the topics of discussion. There usually has to be a proof of notice for your more serious board meetings. There is an exception, by the way, to the 48-hour notice requirement, and that is for what I would consider to be your more important board meetings. For example, a meeting of the board to adopt a special assessment. That has a different requirement. That notice needs to be mailed or delivered to each unit owner. It needs to be posted 14 days in advance. So that's a special meeting of the board. Similarly, a meeting for the amendment of the governing documents or rules regarding unit use. Board meetings for those need to have 14-day notice. A budget adoption meeting, which is a board meeting, the board adopts the budget, 14 days notice by statute. And you also want to be careful. Some governing documents require 30-day notice for some of these meetings. So let's be mindful of that as well, which underscores the importance and this theme that I'm going to keep mentioning throughout this presentation, that it's not only what is provided in the statutes, but also what might be provided in your association governing documents. So that, in a nutshell, is an overview of condo board meetings. As we move on, we now embark upon a discussion of condo members meetings. So generally speaking, the membership of an association gets to meet whenever there is anything upon which the unit owners need to vote upon, or any business that needs to be conducted by the unit owners. And for the most part, in a condo as well as in an HOA, most of the business, most of the affairs of the association are to be conducted by the board, right? You want to enter into a contract. Well, there's no requirement for the unit owners or the homeowners to vote on that. That's a board decision usually. You want to adopt a budget, board decision. You want to adopt a special assessment, board decision. There are typically very limited issues upon which unit owners or homeowners are called to vote upon. And so in many instances, in my experience representing community associations, some members have complained that the board has not consulted with them before taking certain action or doing certain things. And it's not to sound crass or rude or arrogant, but the reality is the board has no obligation to do so. The board acts on its own. That said, the board must, as we indicated earlier, act at board meetings. And therefore, while owners may not have a, quote, say in whether they approve or disapprove of a matter, they, as constituents and as vested participants in the process, do have a right to know what is going on and do have a right to speak about what is going on. Hopefully, their speaking or their voicing of concerns may impress upon the board what their desires may be, and give the board something to ponder in making their decisions.
So Robbie, I want to ask because this obviously gets asked to us a lot as well when there's management change occurring. There's a gentleman named Philip here that's asking, we are considering a management company change. We are interviewing different companies. How can we do this in a closed manner?
Okay, the answer is there is no way to do it in a closed manner. Because and I'm assuming this is raised from the perspective of a condo, but either way, whether we're looking at from a condo or an HOA, you only have closed meetings, as I stated earlier, for the selection of for personnel matters, and usually the hiring of a third-party management company is not a personnel matter because those are not your personnel; those are third-party personnel. So that engagement of a management company per se doesn't fall under that category. And then it also, unless we're being very apprehensive about the management company we're hiring, I also don't think it falls under the category of a meeting with the lawyer to discuss legally privileged information or legal advice in connection with proposed or imminent litigation, because I'm hoping that if you're hiring a new management company, it has nothing to do with proposed or imminent litigation. So under those two exceptions, neither of them applicable to the engagement of management, in my opinion, you technically speaking cannot have a closed meeting. Now, if you don't have a quorum of board members meeting, okay, so if you have, let's say hypothetically speaking, you have a board of 5 individuals, and the documents provide that a majority of the board is a quorum, it is entirely possible for less than a quorum. So in this example, 2 board members could be meeting with the management company or meeting amongst themselves to discuss issues related to this engagement or this proposed business decision. And since it's not a meeting because you technically don't have a quorum, then there's nothing that prevents those 2 board members from having that meeting. Also, there is nothing that prevents board members from communicating via email to discuss these issues, even outside of a board meeting, so long as the board is not making a decision by email. So those are your examples that according to the law, you can clearly work through. You know, I know that some more aggressive legal opinions out there may suggest that if a majority of the board is just having a conversation about something and doesn't make a decision, that is allowed. But I believe that that's a slippery slope. I don't subscribe to that theory necessarily speaking, and I think the conservative wisdom is to have those discussions in the public. And frankly, you know, other than potentially having to have longer and protracted discussion because some or many owners might show up to have a conversation on the topic, there's really no reason why the discussion needs to be had in private as it relates to the engagement of a new company. It may drag out the process a little bit. It may be a little inconvenient, but you know, at the end of the day, the members do have a right to know what's going on as it relates to that.
Correct. And if I can add to that, so because obviously we deal with this pretty frequently. Yeah, it's very common to be interviewed, you know, once or twice, or normally there's a liaison for the board of directors or 2 individuals that are assigned to meet with one company, 2 on the other, and then they put together a metric, and then they can come together of who they're formally going to meet. Further, I mean, with technology nowadays, it makes it much easier for both parties because, as Robbie said, it does drag out the process a little bit longer than what it should be. But you could use the Zoom and meetings such as this to be able to do the interview process in a much more efficient manner. As long as you're not meeting the quorum, then you don't necessarily have to post the notice. Another common question that we get asked, and going just is with the approval of, let's say, of a contract. A lot of times, you know, because of even in the midst of COVID, you don't have the ability to be able to hold a meeting to be able to make that selection for that company, whether it be a management company, an attorney, or whatever other representation. It's not necessarily common practice, but if you had no other choice where you needed to execute the agreement, you can do that, as long as obviously the agreement's being reviewed by your attorney, and then the decision could be ratified at a meeting maybe in a week or two later, saying that you made the decision based on this and you had your attorney review the agreement and whatnot. So those are,
Yeah.
with regards to management,
One
those are
one point
sometimes
of
things that do happen.
right, and that's a good point that you raised, because and we're gonna, I'm sure we'll get into it later on, but we might as well address it now that the cat's been let out of the bag. Our current pandemic situation does present a unique set of circumstances in that, this traditional notion of meetings, physical meetings at which everybody is entitled to attend and be present, is not exactly feasible, let's say, for a number of reasons, right? We either want to be mindful, or maybe some individual owners can't attend, and so in an effort to allow participation, many associations have looked into the establishment of virtual options, such as what we're doing right now, with Zoom and other alternatives out there that allow for the participation by members at these meetings. The statutes don't exactly address this, not entirely, and so what we've been doing to some extent is we've kind of like been making this up. We're inventing, we're building the plane while we're flying it,
Yeah.
as some have stated.
Yeah.
And so we try to do as best we can to accommodate all of the needs. What do I mean by that? Well, both for condos and HOAs, there is a statute that addresses emergency powers. Mm-hmm. And when this whole pandemic started back in March, and everything closed down, and people were asked or ordered to stay at home, and people couldn't attend meetings, then board members would ask us, well, we need to have a meeting, we need to do stuff. Business must go on for condos. We still need to pay bills, we still need to hire and fire contractors, we still need to do certain things. We still need to adopt budgets. We still need to do so much. So, but we can't meet. So what happened? We started looking into the statutes for emergency powers, and we realized when you read the statutes that allow board members to adopt emergency powers, that there are certain elements. Well, one of which is there must be a declared state of emergency. And you know what? We had that. There was a declared state of emergency. But when you read the statute says, well, in the event that there's a declared state of emergency, a condo board may establish or adopt by resolution at a meeting the creation or use of emergency powers. And this statute gives board members a lot of authority of what to do. You can adopt assessments without notice. You can suspend certain meetings or certain meeting requirements. But when you look at the statute, it says that you can adopt these emergency powers in order to prevent damage. And then people started debating, well, we're not really preventing damage. We might be preventing injury or infection, but we're not really preventing damage. And then some people started saying, well, you might be preventing damage, because if an area gets infected or if it gets contaminated, then maybe it's a damage. Maybe the virus is causing damage to people. So everybody started debating, well, there is damage, and then we start, as lawyers, we start trying to get creative in analyzing and interpreting the provisions. And so we started saying, look, it is possible that this statute was created at the time, or perhaps with something more common in mind, right? Hurricanes, let's say, tropical storms, and the type of damage that might ensue from those natural disasters. But a lot of our, colleagues in the legal profession that represent community associations, I believe the consensus overwhelmingly was that this section, these statutes do apply to these types of situations. And I want to make the caveat. It's been a leap that a lot of us have been arguing that those statutes apply. We think that they are very good arguments, but there hasn't been any court case or precedent affirming that interpretation. And while there are efforts legislatively to elaborate upon those statutes have not been modified to extend specifically to pandemic type circumstances. Nonetheless, many of our clients have invoked the emergency powers, and I think it is a good idea to do so, because by virtue of doing that, then you have the ability to do a number of things like create other procedures for the purposes of holding meetings. And what does that do? It opens up the door now to create new procedures for attendance by members at member meetings virtually. This again is an argument. None of these things, I am here to say, none of these things are black and white. None of these things have been endorsed by any court case, because the truth of the matter is the courts are extremely backed up and are operating on very thin sets of procedures themselves. So there's not a lot of I would say typical access to courts which were notoriously slow anyway before the pandemic. So we really don't have a lot of legal precedent upon which to support the decisions and the recommendations we've been making. Nonetheless, as I stated earlier, in the theme of building the plane while we're flying it, if you're going to be an association that is going to encourage participation by members virtually, and what I mean by participation by members, you can allow them to participate passively at a meeting, and that is you have a webinar or a Zoom type meeting established, and they can watch and listen, but are they really actively participating? Are they voting? Are they asking and getting their questions answered, which would typically occur if they were physically at a meeting and were there to ask questions and have their questions heard and addressed? So is there anything that addresses that in the statute? The answer is no. And so as a result, we've come up with these concepts and nuances of adopting the emergency powers, adopting resolutions for modified election procedures or meeting procedures, and now we create some set of rules and some semblance of formality for that process pursuant to which members can now participate. And so we are also mindful, because one might ask, the statutes allow for electronic voting. And so, can't we just open up a Zoom meeting and let people, vote by show of hands? Well, it's not so easy. The statutes do address electronic voting. But that doesn't mean that you open up a Zoom meeting and somebody can raise their hand or post their vote on the chat and that counts as their vote. That's not how electronic voting works according to the statutes. And so, we did take advantage of this pandemic to now, and when I say we, I'm speaking globally, the stakeholders and community associations, to have this process of electronic voting now flourish, and it's become more and more embraced. And so what you do find is a process whereby some associations are invoking the emergency powers, establishing new meeting protocol and procedures and new election procedures, in adopting formally electronic voting, having owners get the opportunity to opt in and to vote electronically. And because of all of this, now you have this very hybrid, system of collective, pieces that have been put together to allow for, I guess, the best plane we could have built during this process with the tools and materials we were given. So it's not a perfect system, but I think that we've gotten close to it, given all the tools we have statutorily, as well as from a corporate perspective, and also from a common sense and technological perspective. because again, what we want to do is try to mimic and mirror the ideas that the statutes anticipate and contemplate for meetings and for members to have the right to participate, to listen, to watch, and to learn. And so while on a technically legal perspective, I might tell you, hey, Ralph, no, a member cannot technically vote at a members meeting via Zoom, and you might say, well, that doesn't make sense. It's not right. It's not fair. I can tell you, well, but let's look at another way of doing it. And maybe we can address certain aspects of trying to, as best as we can, formalize the process so that we can get as close to the traditional notion of a meeting and participation at such meeting. And so that's my digression, I guess, on the current day pandemic and the new I guess, workarounds that we've had to consider with regard to condo and HOA members meetings. Now, I don't know if you have any other comment to ask me or question to ask me, because I noticed you put the other slide up there, and I also recognize we want to move along on the topics that we're here to discuss. So I'll give you the floor. And
yeah, sure. So I have a question here from Phyllis. For the purpose of quorum, does the statute designate that a simple majority 50% plus one? She didn't place either 718 or 720. For the purpose of quorum, that really all depends, right? Because as Robbie has stated in the beginning of his presentation, it depends on which quorum, quorum of a board member, quorum of an annual meeting, quorum of an election. So
right,
that's all dependent.
And so to answer the question, if the governing documents of the association are silent, then both board meetings and unit owner or homeowner meetings have a quorum of majority. That's what's provided in the statute. So if your governing documents don't say anything about what the required quorum for a members meeting is, then the members meeting quorum is a majority of the members present at a meeting. And by the way, proxies are allowed. And your governing documents should speak to that. There are some governing documents that don't allow proxies, by the way. But as it relates to proxies, one important distinction we want to make between condos and HOAs is that in condos, the use of a general proxy, which is a proxy that allows the proxy holder to vote on any matter at the meeting, is limited in condos for just establishment of quorum and practically just for the adjournment of the meeting, adjourning and reconvening the meeting. That's all you could use a general proxy for in a condo. However, in a condo, you can use what is called a limited proxy for certain issues because the statute allows that use in condos. Now, it's important. In a condo, you cannot have a board member elected by proxy, particularly because the election is not taking place as part of the annual meeting. Remember, I said it was an independent process. And so since the election is not taking place as part of the annual meeting, but rather during the annual meeting or during the night or day or time of the annual meeting, then you really can't vote by proxy in a condo for directors. However, in an HOA, you could vote by proxy unless your governing documents establish otherwise. And again, the distinction is in an HOA, the election of directors is happening at the annual meeting. And therefore, in an HOA, if you don't have a quorum of members present, then you cannot have the election. And similarly, in an HOA, if a member appoints a proxy holder to show up at the meeting on their behalf, then that proxy holder, even if it's a general proxy, may be able to vote for directors, for candidates. And again, I caution that we need to be very careful between what the governing documents provide, because, for example, in HOAs, governing documents may allow the use of general proxies and may allow voting with general proxies on matters except elections, right? the HOA documents might, for example, say that even though you can use a general proxy to establish a quorum, you can't vote for directors by general proxy. So I mentioned this just for an illustrative purpose of saying we want to be mindful in an HOA of what the governing documents are, as well as in a condo, but it is emblematic of why you need to be mindful of what the documents provide. And so in the slide that you have now, I know it's applicable to condos, and we'll run through it real quick, and just to also address the nature of what we have going on in the slides. But that is, in order to have an election in a condo, we need to make sure that a minimum of 20% of the ballots have been cast by eligible voters. And once we do, remember, it's a 2-envelope system in a condo. You've got the outer envelope and the inner envelope. The ballot is supposed to go, and it's a secret ballot. It's supposed to go in the inner envelope. The inner envelope should have no place for an owner to sign their name or put their unit number, because the purpose of the 2-envelope system is to preserve the anonymity, preserve the right of an owner to remain anonymous in how they voted in a condo election. And so the concept is you put your ballot in the inner envelope, and then you put that inner envelope, which should have no indication of who voted that ballot, you put that inner envelope inside of the outer envelope. The outer envelope, by contrast, does have a place for the owner to sign their signature, to print their name, to indicate their unit number, because that outer envelope, the purpose of it is to allow us, whether it's management, whether it's an election monitor, whether it's an inspector of an election, whether it's the attorney handling the election for the condo, it's to allow us to identify who voted and to make sure that the eligible or qualified voter for a unit has voted. And so we'll look at that outer envelope with that purpose. And then when we do start the annual meeting, or strike that, the election, and we do determine that we reach the 20%, at least by virtue of analyzing the outer ballot envelopes and whether or not they've been validly cast, then we begin to open up all of the outer envelopes first. And the law does not allow us to open up the inner envelopes until we've opened up all of the outer envelopes, because the idea is, if I open up the outer envelope for, Joe Johnson, and then I open up Joe Johnson's inner envelope, then I could see how Joe voted. But the statute and the administrative rule requires that we open up all of the outer envelopes first, separate the inner envelopes, and then once we're done opening up all of the outer envelopes, we separate that, and then we start opening up all of the inner envelopes. And I guess what the legislators are banking on is that none of us have a photographic memory of exactly, how all of those inner envelopes, or where they all came from. So, and I can tell you that I myself have been unable to remember exactly how everybody, where all of those inner envelopes have come from. So we want to make sure we've got the 20%. We want to make sure it's been the authorized voter who submitted the ballot. And in some cases, we want to make sure that we have voting certificates where required, because some governing documents for condo and homeowner associations specify that depending upon how a home or a unit is owned, is how the vote may be cast for that home. For example, if a unit is owned by a corporation, who has the right to vote for that corporation? Is it a shareholder? Is it the president? Is it the director? Is it a secretary of that corporation? Is it the banker for that association? Is it the person who lives in the unit? We don't typically know. And so in many instances, when you have units owned by legal entities such as corporations, you will see that voting certificates are required for those units. And that voting certificate is simply a document that indicates who is authorized to vote on behalf of that unit, okay? And so we're also mindful with regard to annual meetings and elections in condos of the necessary deadlines. We know that 60 days before the election, we need to have the first notice given, and that's an invitation for owners to submit their desire to run. We invite them. We say, hey, unit owner, eligible candidates, if you are interested in running for the board, we're letting you know that not less than 60 days from now, there's going to be the annual meeting and election. If you want to run for election, please submit your candidate information sheet back to the your candidate application form back to the association, and you must do so not less than 40 days before the election. Similarly, owner or eligible candidate, because by the way, the statutes don't indicate that only owners can run for the board, right? There's a preconceived notion throughout many community associations that only owners are eligible to be on boards, and the statutes don't make that distinction. However, your governing documents may. So you want to be mindful of what your governing documents provide as it relates to eligibility to be on a board. But going back to the point, when you're inviting somebody to submit their nomination by virtue of a candidate application form for an upcoming condominium association election, we then provide them an additional 5 days. So therefore, no less than 35 days before the election, a candidate who chooses to do so could submit their resume or their candidate information sheet. And that document, if a candidate opts to submit it in a condominium association, cannot exceed one side of a sheet of paper that is 8.5 by 11 inches in size. And the candidate could put whatever they want on that sheet. You as the association cannot force a candidate to put certain information there. You cannot prevent a candidate or preclude or restrict a candidate's ability to put whatever information or documentation they want to put on that sheet of paper. And by the way, as an association, you must send that out with your second notice, and you are also protected from whatever the contents of that candidate information sheet or candidate resume is. And then, of course, once you get those resumes and once we identify who submitted candidate application forms and who's nominated themselves, then we determine if we're going to have an election, right? So if you have a board, for example, of 5 board members, and all of those positions are going to become vacant at the annual meeting, or at the election, then we know that if we get 5 candidates or less, there's no need to have an election. If we receive more than 5 candidates, then we must have an election. And so our second notice in that case will have to include the ballot. It will have to include the inner envelope, the outer envelope. And so we will invite members of the association at that point, vis-a-vis the second notice, to submit their ballot and send it back to the association, either by hand delivery or by mail. But it cannot be sent by fax. It must be sent in the inner and outer envelopes, as the statute contemplates. The owner can hand deliver it. The owner can submit it on the day or night or time of the election. And going to the qualifications, because I mentioned earlier who can be on the board. Well, on the slide it indicates it. It says if you have been convicted of a felony and your voting rights have not been restored, then you cannot be eligible to run on the board. If you're not over 18 years of age, you cannot be on the board. If you are co-owners of a unit, you cannot be on the board if it is a condominium of more than 10 units, unless you guys as co-owners own more than 1 unit, or unless there are not sufficient candidates. And so those are your, generally speaking, eligibility criteria in a condominium association election. Now, moving on to the next slide.
I have a question here, Robbie. It says,
Yes,
how long are voting certificates good for?
Voting certificates are good forever, until they are either revoked or replaced by another voting certificate.
Correct. And I have another question here from Estella, which I'll chime in. It says, basically, can the board expand the amount of board members from 5 to 7 during the election? And, we get asked that question all the time. Basically, your documents, and correct me if I'm wrong, Robbie, your documents are going to outline how many board members are permitted to sit on the board of directors. If you have a range, let's say 3 to 9, the arbitration cases have held that it needs to be 5. But yeah, you should definitely stick to whatever your documents state. If you're going to expand that, that's going to be a process. If you need to expand that, you'll need to technically change your documents. Is that correct, Robbie?
Well, I would say for the most part, yes. You have to see what your documents say, and some documents do allow the board alone to increase the size or decrease the size of the board. Um, but it is my experience that a very good number of governing documents, to not say many of them, or a majority of them, because I don't really know if it's a majority or not, but it is a very good number of governing documents, do limit your ability to increase the size or decrease the size of the board, um, by virtue of requiring a unit owner or a homeowner vote on that
Oh,
topic.
yeah,
So
good point.
you can't assume that it is that easy of a task to accomplish. And so in some cases, it might require an amendment to documents. In other cases, it may just require a vote and a resolution. So it is something that should not just be dismissed as a given, right? You want to be careful about how it's done.
Valid point.
So we mentioned that board members are elected for a certain term. The terms usually are from election to election, from one year to the next. Some governing documents might allow for staggered terms of 2 years, but that needs to be specified in the governing documents. Similarly, if there's going to be a vacancy on the board, let's say that a board member resigns, or let's say that your governing documents provide that a board member must be a unit owner, and that board member now sold his or her unit. As a result of that, you now have an instance of ineligibility that creates a vacancy. Or as I stated earlier in my example, the board member resigns, now you have a vacancy. So typically speaking, the board has the right to fill that vacancy. Most, if not all, governing documents that I've ever reviewed give that right to the board. And the board usually has the right to fill that vacancy for the unexpired term that was to be served by the candidate, by the director that created the vacancy, or whose position the vacancy had previously been occupied by. I also want to mention, as it relates to this point, which is on the slide, and it's a very important issue, and is this notion of, in condos, a term limit. And many people ask this question, and they say, well, so-and-so's been on the board for 10 years. The statute says you can't be on the board for more than 8 years. Well, the statute does say that, but there has been a case or an opinion by the Division of Condominium that has indicated that the critical date from which we start counting that period of time is from, I think it's July of 2018, if 18. I'm not mistaken.
Yeah, I think it's 18.
Yeah, and that's when the statute became effective. And so you might have had a director that served for the last 20 years, but we start counting those 8 years from or after July of 2018. And by the way, it doesn't prevent that person from being on the board. It prevents that person from being on the board only if there was nobody else, if there were no other candidates, or if he or she did not get votes from more than 2/3 of the votes cast at the election. So, we want to be mindful of that. And
So,
the last
Robbie,
point,
if you don't mind, I want to interrupt you here because I recently had this question asked to me in a sales meeting, and what someone did was they said, what happens if someone's running for the board, they resign for 2 weeks, the current board brings them back on? Does that automatically reset those 8 years? Obviously, assuming that it was in 2018, right? That the start date starts. But what happens in a situation like that? Because I don't know if it outlines
I've heard similar questions. I don't want to call them underhanded or sneaky,
But, we never get those questions.
but let's call them very interesting questions, right?
Yeah.
And it is a good question, because what the statute says is no director may serve for more than 8 consecutive years. And therefore, if there was a cut, if there was a gap within that consecutiveness of years, then presumably the clock starts ticking again. So hypothetically speaking, and I'm not aware of any court ruling on this, I'm not aware of any division of condominium ruling on this, so I don't know what the arbitrators or the courts will do with this type of an issue. But presumably, if you have a director who served, let's fast forward, we're now in the year 2028, and the person served on the board from 2018, all these years, and we get to the point that he definitely has served more than 8 years, and he had done so since or as of 2018, and so clearly he would have been ineligible. However, he resigned from the board maybe a week or two before the election, right? So now he broke that cycle of continuity before the time during which he gets elected. The question becomes, is he eligible at that point to start a new term and a new service to the board? And I would tell you that you know, a creative and literal interpretation of the statute would suggest that he could.
Yeah.
So now I will also tell you it hasn't been tested, and I'm not aware of any challenge to that yet, probably because, you know, there's a pretty good consensus of the fact that the 8 years starts ticking as of 2018. And so I don't think we've gotten anybody yet that has reached that 8-year limitation from 2018. But, you know, as we move on in time, and as we get to 2026, and thereafter, we're going to start having some interesting situations. So,
yeah. I have an interesting question here, which actually, you know what, I'm going to hold this for the next slide because I think it'll relate more to with the next slide.
Yeah. So just to finish off on this particular slide, we have this issue of the certification form. You know, the statute provides that a candidate who is newly appointed or elected needs to either sign a form, which we call a certification form, which includes a lot of representations by the candidate. You know, they're familiar with the laws and the governing documents of the condominium, and they know what to do, and blah 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 blah. So it's a self-serving form. Or in lieu of signing that form, they could take what is called a certification course, and statutorily, as well as the division rules, do recognize the ability of a course to be given to these directors, both in condos and in HOAs, within 90 days from the time that they are appointed or elected. And when they take that course, then they have complied with the certification requirement. An association needs to keep a certificate of that certification for 5 years, or the duration of that director's uninterrupted tenure on the board, whatever is longer. And so as a board member, if you serve on the board for an uninterrupted term, and once you submit that certification or take the course, then you don't have to take it again.
Excellent.
Next slide.
I have a question here, Robbie, right back to what we were chit-chatting about. Is the limit of number of years is for both condos and HOAs?
No, only for condos.
Condos only, correct, yeah.
Yeah, only for condos. So now in this slide, we address condo recalls, and for the most part, recalls and HOAs are very similar as well. And what I'll try to do is speed through this because I recognize that we're getting close to our time limit here. But the bottom line here is that there is a very technical procedure of how to remove directors, and directors can only be removed by recall. And the procedures for recall are provided in the statutes and in the administrative code. And bottom line is that a majority of the members, a majority of the unit owners are the only people that can vote to remove a director or all of the directors or any number of directors. And there's two ways to do it. You can either petition for a meeting of the members to take place during which the members are going to vote to recall the director, or the more common approach is to do it by what is called a written agreement. But it's not just a petition signed by everybody saying remove Ralph from the board. No, that's not the way it's done. It is it's a standard form that you can find on the Division of Condominiums website. It's a 3-part form. It's got part A, part B, part C. You as the owner, as the voting member, need to fill out information about yourself so that we can determine if the person submitting this recall form, this recall agreement, is the eligible voter. You also then in part B need to indicate who is being recalled. Are you just recalling one board member? Or are you recalling all of the board members? And if you recall a majority of the board members or more, then you also have the right to designate who the replacement board members are going to be. So in this part B of the recall form, you would indicate not only who you want removed, but if you're doing it for more than a majority of the board members, you need to say who is going to replace those people. And then in the last section, you have the section for signature, etc., and who is the representative of the group of owners voting for recall. If these recall agreements, by a majority of the recall agreements, are served, not a majority of the recall agreements, but if recall agreements from a majority or more of the members is served, and by served, I just mean delivered or handed or mailed or received by the association, and that could mean the manager, a director, maybe the attorney, then the board needs to act, and they need to call a meeting within 5 business days. They need to determine whether or not the recall effort is to be certified or not certified. If it isn't certified, they need to file a petition for recall with the Division of Arbitration, with the Division of Condominium, with the arbitration section of the Division of Condominium. And then that arbitrator will determine if the recall effort was facially valid. Did it comply with the technical procedures of the statutes and the rules governing recall. So that, in effect, is the process pursuant to which a recall takes place, and it is very similar in the HOA setting. The next slide indicates that for HOA board meetings, most of these procedures are almost identical to the condo, with the exception being that, as indicated up top, the statute also indicates that members have a right to speak and attend board meetings and to speak for 3 minutes on agenda items. One of the things that I failed to mention earlier, and I want to emphasize here for condos, is that there is, if you're 150 units or more, you are obligated to have a website, and your website must provide for the posting of notice of board meetings and members meetings. You got to include agendas, you got to post meeting minutes, etc. I mean, there's a very technical requirement for what needs to be done at board meetings, through that website. And if you are a condo of 150 units or more, I want to draw your attention to that, because many associations are not focusing or paying attention to that. Now, in an HOA, the board could adopt procedures, or the association could adopt procedures for notification by website, etc. But there's the same procedure, the same requirement doesn't apply to an HOA setting. Okay. So that should address most of this slide, because as I stated earlier, that board meetings for condos and HOAs are to a large part very similar. And so we can move on to this slide. Now, HOA members meetings. Here we do find some subtle nuances between the meetings of HOA members and the meetings of condos. For instance, default quorum at condo meetings of members is a majority, unless otherwise provided in the documents. In an HOA, the quorum may be no more than 30% of the total voting interest. So this is also important because, as I stated earlier, in order to have an election at an HOA, you need an election of the board in an HOA. You don't have an independent election process. It is happening as part of the annual meeting, and therefore you need to have a quorum of 30%, or it could be less, in an HOA to have a meeting. And if you do reach that quorum, then you can have your election. But if you don't reach that quorum, then you can't have your election. And that, again, is the relevance of proxies in an HOA setting, because, as I stated earlier, while you cannot vote by proxy for the election of condo board members, you could vote by proxy for the election of HOA board members, unless your governing documents don't allow it. Okay, so that is a distinction between condos and HOAs as it relates to proxies and what they could be used for. I think this slide is pretty self-explanatory. One important distinction with condo versus HOA elections is that the laws governing HOAs provide that nominations of candidates are to be taken from the floor. And then there's another procedure, another provision that talks about the fact that there could be alternatives to this if there are alternative procedures established in the HOA documents for nominations to be presented in advance of the meeting by proxy. But the relevant provision is found in section 720.3069A Florida statutes. And it says, except as provided in paragraph B, all members of the association are eligible to serve on the board of directors, and a member may nominate himself or herself as a candidate for the board at a meeting where the election is to be held, provided, however, that if the election process allows candidates to be nominated in advance of the meeting, the association is not required to allow nominations at the meeting. So this is from the statute, and it underscores the relevance of having, once again, to review the governing documents in addition to the statutes. As I stated earlier, disputes of HOA board meetings go to the arbitration section of the division, and we can move on to the next slide, Ralph. Recalls, again, very similar to the condo recall procedures, and there's also jurisdiction with the Division of Condominium to oversee disputes regarding recall matters for HOAs. Next slide. Electronic voting, we discussed earlier, is allowed for condos and HOAs. There needs to be an electronic voting system, which is a term that is referenced a lot in the statutes, both for HOAs and condos, that address electronic voting. You do not have electronic voting as a matter of right in condos or HOAs. The board must establish it by virtue of holding a meeting, adopting a resolution, specifying a lot of parameters within the resolution, providing notice to the members of the establishment of electronic voting, providing an opportunity to owners to opt in, providing an opportunity for owners that have opted in to opt out, using an electronic voting system that meets the requirements, criteria, and thresholds of the statutes. So it is a tedious process, but it is a process that becomes very user-friendly in the hands of the right voting system, electronic voting system operator. I believe that if your association is going to look into doing this, that it do so with a third-party vendor that is qualified and capable of doing this. I don't like it when lawyers do this. I don't think lawyers should be doing this, at least That's my personal opinion. And usually I'm not aware of any management company that does it, but I think that you want to create a certain level of arm's length between the operator of the electronic voting system, as well as the people that are, in the day-to-day trenches with the association, such as the lawyer and the manager. So, but that's just one lawyer's opinion on this topic. And the next slide, we open up the floor to Q&A. I think we've got a few minutes left on our budgeted timeline. So Ralph, what I'll do is I'll let you ask the questions.
Sure, of course. I have here a question from Lori. It says, in an HOA, if statement of qualifications is requested from all persons who wish to run for a position on the board and responses are received prior to the stated deadline, is there a requirement to actually publish those to the membership in a timely manner so that the members vote from a point of view of knowledge? What are the ramifications if they don't publish any at all?
Right. So this
qualifications.
Yeah, and I noticed in your question, I think this is from an HOA's point of view.
So that's correct.
In a condo, the association must send out the resumes. In an HOA, the statutes don't address that. In fact, the statutes don't even address resumes or candidate information sheets, and therefore there is no requirement to send them out unless, I would say, the governing documents provide otherwise, or if there was a representation made on the association's behalf to the candidates that these resumes would be sent out, then I believe you open up the door, or you create the argument that they had to be sent out. Similarly, if you sent some information sheets out and others you don't, I also think that becomes problematic. But if we're just looking at the traditional notion, and there's nothing in the governing documents to the contrary, or no communication has been made establishing a commitment to do so, then there is no requirement to send them out.
Excellent. And I have here from an HOA, what happens if the board member does not take the certification class or sign the affidavit?
Then they are automatically off the board after the 90 days until they take the certification or issue the certification. Now, this is kind of foolish in a way, because the statute gives them an easy way out in the sense that they could just sign the form. But it has happened on occasion. Correct.
Yeah, no, I find it much easier for board members to take a certification. It's much easier to sign the certificate, the affidavit, but at the end of the day, it's better to be able to attend a course for a couple hours and really get a better understanding of the day-to-day of the dealings of what we have to deal with. It also makes it much easier for management when you're dealing with an educated board member.
Yeah, absolutely.
I have here, Carol's asking, how long must a candidate be delinquent to not be eligible? Is it 90 days what's the dollar amount?
90 days. Let's see. Actually, no, I believe there's just a delinquency in the payment of monetary obligations.
Correct. I believe that was changed. Correct. That was changed. Yeah. And so anything that is owed. So there's been a lot of tricks played, or that I've heard of tricks played. So if you're looking to run, just make sure that your account is at zero whenever you're turning in your, well, it depends if you're in an HOA.
It's any delinquency in a monetary obligation.
Correct. Oh, this one's interesting. If a director is not mentally able to serve, can he be removed from the board? I've actually dealt with something like that years ago.
Yeah, well,
they had to vapor act the gentleman.
The answer is if it was a given that they lack the mental capacity, then I would tell you the answer is yes. But how are you going to determine or establish that they lack the mental capacity? And so, that becomes the more tricky issue to resolve. And so, that may require, as you stated, a Baker acting, maybe a guardianship procedure. I've never seen it happen. Let's just put it that way.
Yeah. And ultimately in these kinds of things, I try to educate board members that sometimes it's even easier. Remember that it's not one, well, there shouldn't be one board member making all the decisions. That's the purpose of having a collective group, so that, the decisions are balanced and for the well of the association. It's actually easier and more cost effective to just prepare to get that person removed. If they just got elected in, then you have your recall process, which that's a process of its own. But actually just preparing to get that person removed in the next election and doing whatever campaigns is necessary would be probably more cost effective for your association, assuming that individual is not causing any financial damage or other damage to your community.
Absolutely.
We have a question here that has to do with online elections. So it says the person who organized our host, which is a company that does online election, neglected to include a provision to vote on the rollover. We did include a provision to indicate a proxy option, but it didn't explain why. Can we use the proxy to vote on the rollover if it wasn't on the ballot?
This is on the rollover of funds, of budgetary funds, I presume?
Yeah, I am not sure. I'm assuming it's that because I don't think it could be anything else.
Right.
I don't see
Yeah,
what
I
else
mean,
you have to vote on.
anything you vote on, anything the members vote on has to be in the notice of the meeting. It has to be in the agenda. And if you don't include it in the agenda, then, and I know a lot of meetings, agendas have new business, and people make the argument that, this is an item introduced under new business. And, I don't like that argument, especially not when you're exercising a vote. So I would prefer an item be listed on the agenda. And then if you are in an HOA, a general proxy is okay for that vote, unless your association documents don't allow the use of general proxies. If you are in a condo, the limited proxy must be used because a general proxy cannot be used for that. Though some accountants with whom I've spoken to have indicated to me that a general proxy would be okay because it's more for compliance with tax regulations or IRS regulations. So those are my 2 cents on that issue.
With regards to procedures for out-of-country owners regarding emailing of ballots. So in a condo, you won't be able to do that. In a condo, you're going to need to have that mailed in.
Well, you cannot email ballots in a condo ever. I also don't think you can email ballots in an HOA because the only way you can vote in an HOA is at the meeting by proxy. Right. And of course, what we've started doing now, pandemic times, is establishing certain procedures for voting vis-a-vis Zoom, which I am not 100% convinced with, but we'll see what happens. Maybe they're enforced, maybe they're not. We'll see. Nonetheless, this is a very real issue, especially in our South Florida market, because there are so many homes as well as condos that are owned by foreigners or by people that live abroad. Right. And we also know that the mailing system and even the parcel courier delivery systems are extremely overtasked. So because of all these issues, we become proponents of the electronic voting system. And so that is the way to work around this. It is, if you have a good number of owners living abroad and you actually want to encourage their participation and their votes, right? Because, motives may also be that we don't want people to vote, yeah. but if you have the motive to allow people to vote, then electronic voting is, in my opinion, the save-all for this issue.
Right. Correct. No, and I would agree. I mean, it provides, it's like, as you stated, with all the out-of-towners, and also we don't know how much longer we're going to be dealing with the pandemic. So now is the time. If your annual meetings are towards the end of the year, there is a process that has to be followed. You have to speak with your attorney. You have to have the procedures approved at a board meeting. And then outside of that, there is some challenges that we have to deal with. And again, not being against it, it's just making sure that you're planning properly. Is that, tying which email is going to tie to the person that can actually vote for that unit. So there are some procedural back office things that do need to be addressed. So if you haven't done so yet, I strongly urge that you do it, because it is the future with regards to voting. We have here, and I guess this goes with Katie, has to do more with contractor bids and do they need to be provided to the members upon request? So I'll take that one. Katie, yes, any items that the association has that like bids and contracts and so forth, the members do have the right to request it and it must be provided. However, as Robbie stated earlier, if you're a condo, hopefully in each way you're following kind of similar practice with the website. You should have that already posted up because those are requirements, especially for condos, that you have those contracts and bids posted up on the website. So that's going to eliminate work for your management company, or if you're self-managed, for your on-site team to be having to provide that information. Let me see what else we have here. Okay, I have here, who can force a board to have regular elections? The board has canceled, arguing emergency powers for COVID. DBPR is washing their hands.
Yeah, I mean, this goes back to one of those issues that we are going to have to contend with, and the reality is that the emergency statutes do allow for the suspension of meetings if they've been properly enacted. So it's a lot of what ifs, of course, but I could see why the division is punting on that issue. And as I stated earlier, until there is some precedent, we are in this state of uncertainty as it relates to that condo, and particularly unless one of those affected owners files a lawsuit or some type of arbitration proceeding, we may not have any resolution to that issue.
Yeah, I agree. I mean, the most challenging ones, at least for us, has been the HOAs because of the requirements of being there. For the condos, we've been fortunate enough that with the condos, you just have the ballots mailed to a particular location, and you could still technically host the meeting on Zoom. On the HOA side is where it's been much more challenging to be able to meet certain requirements. But again, if you're communicating to your residents of why you're making these decisions, then you should have less resistance from the membership. Let me see here. We'll take one more. It says here, well, it's going to answer that one. Let's go through here. It says here, okay, this is a little bit different from our topic, but I do get this question, so it'll be great. It says, it seems that when looking for specifics in 718, the answers are not easily found. Well, that's what you have an attorney for. When requiring screening with background checks for renters and or buyers, the statute states that only $100 may be charged. How much extra can be required to cover costs for international background checks?
There is and by the way, this is a very delicate issue. So the statutes provide that, and this relates to condos. The statutes provide that if you have the authority in your documents to approve or disapprove an occupant, whether it's a purchaser or a tenant, then you may charge a fee, but no fee may exceed $100 per applicant. And for example, a parent and dependent child relationship or a husband and a wife type relationship is considered to be one applicant, even though you have two or even more individuals that might be residing or occupying that unit. So you're limited to $100. You use that $100 wisely. If your cost of doing background checks is more than that, too bad. Cost of doing business for the condo. If you charge more than that, you could be doing so at the risk of getting sued, and be forewarned that there are lawyers out there taking on class action lawsuits and trying to make a name for themselves and a reputation for themselves. It's kind of like another wave of ambulance chasers. So, I get that our clients don't like that answer, and I can understand that our clients feel that $100 is nothing. But they shouldn't be complaining to us. They should be complaining to the people that make up the laws in Tallahassee, and you could have that law changed very easily. Lobby your your legislative representatives.
Perfect. Well, with that, I want to wrap up in respect to your time, Robbie, as well as the respect and time for all the board members and managers that attended today. I personally wanted to thank you. I wanted to thank Stephanie and Ashley from our team for helping put this webinar together. And more importantly, I wanted to applaud all the board members that are here today, especially the managers, for taking time out of your day. We get paid for what we do, you don't. So I want to applaud you for taking that, putting in that effort to get better educated, to better serve your residents.
Ralph, thank you so much. And I echo your statements as to those who participated and submitted questions in particular, because it provides us with a platform for everybody to continuously learn. I know that I'm probably also speaking for you that I myself am continue to learn every single day in connection with our interactions with our clients and our other community association stakeholders such as yourself. So we appreciate this opportunity to present and also to learn from yourself and from all those participants and the questions that were brought up.
Thank you, Robbie. All right, everyone, have a great day, and we'll see you at the next webinar. Bye-bye.
You too. Bye-bye.